Hi,
Hello.
welcome to the Beginner's Guide to Child Custody and Guardianship. My name is Nirna Serrano-Setti, and I'm an estate planning, elder law, probate, and guardianship lawyer in Tampa, Florida. And I am one of your hosts this afternoon. I'm happy to be here.
Hi, everybody. I am your other host. My name is Stacy Perez. I am a family law attorney here in Tampa, and I'm also a certified family court mediator. So a lot of us are facing challenges during this time and having a lot of questions about how do we go about our daily lives, a lot of other things. And so one of the main questions that Myrna and I are getting in our practices right now revolves around the difference between child custody and guardianship. And so that's what we wanted to talk about today, and just provide a little bit of information and share with you some ways that you can keep your family safe and make the best decisions for their future. So one of the most common questions that I'm getting right now in regards to people who are caring for a child who's related to them, whether it's a grandchild, a stepchild, maybe a niece or nephew, whatever it may be, it revolves around what documents do I need to have custody of that child and to make decisions for them. And if you don't have custody yet and you're concerned about that child and maybe want to obtain custody, how you go about doing that. And so a lot of these days, grandparents and other family members are finding themselves stepping into the role of a parent for a child in their family. A lot of times, parents aren't able to properly care for their kids. They may be going through a rough time. And so, you may find yourself, stepping into the caregiver role for a younger member of your family. Now, you could find yourself in a little bit of a legal pickle if you don't have the proper documentation to really spell out what your role is with that child and what authority you have to make those decisions. And so that's kind of something that I want to talk about today. And for our purposes today, we're going to use the scenario of a grandparent caring for their grandchild, because that's one of the most common scenarios that I see in my practice. But just know that these options are all also available for extended family members and step-parents as well. Next slide, please. So in Florida, there are two types of custody for extended family members. So the first question that we need to have answered is, what type of custody do you want? And so, like I said, there's two types. There is temporary, and then there is also concurrent custody. So in our next slide, I'm going to explain to you exactly what the differences are between those two types of custody so that you can make the best decision regarding what option fits your situation. So let's start with temporary custody. This is the type of custody petition that you're going to be asking the court to decide if you have a valid reason to think that a child has been abused, abandoned, or neglected. And in this scenario, the Department of Children and Families is not already involved in with the family. If one or both of the parents objects to you having custody, you're going to end up filing a temporary custody petition. Now, the court can grant your petition even if a parent objects, but they have to agree and they have to make the finding that that child has been abused, neglected, or abandoned in some way. So once the court grants your petition for temporary custody, you're going to step into the parent's shoes. You're going to be able to make decisions regarding medical decisions for the child. You're going to be able to make educational decisions for that child, as well as anything else day to day that you would need to do for that child to give them the best care that you can. Now, over with concurrent custody, this is the option that allows for an extended family member to obtain custody of a child if both parents are in agreement. Now, if one parent objects, it's going to have to be turned into a temporary custody petition. But if both parents are on the same page and they both are in agreement with you having custody of the child, it's going to be termed concurrent custody. Now, in order for this to be granted, the child must have lived with you for the past 10 of the last 30 days. And this is also an option that gives you and the parent the ability to continue making decisions for that child kind of on a co-parent basis. Now, both of these options are open to relatives and step-parents. If you are not one of those, then it's going to be a different kind of custody that we'll discuss in a different setting. Next slide, please. So a couple other things that are important to know about these two types of custody in Florida is that at any time, the parents could request the court terminate the custody agreement and restore the child back to custody with that parent. Now, under a temporary petition, the court would have to make a finding that that parent is now fit to care for the child and that it's in the child's best interest to be returned to that parent. And also, something that a lot of caregivers have questions about is child support. And under Florida statutes, specifically statute 751, caregivers could be entitled to child support from one or both parents. They will just make that determination when they're determining whether or not to grant your custody petition. So next slide, please. So obviously something that is on everybody's mind right now is how does this COVID-19 pandemic affect custody issues? It's affecting every aspect of our lives right now. So it's definitely going to have some impact on custody. And so one of the biggest things that has been coming up lately is if one party feels concerned about visitation with by a child with another parent or another party. And so just know that if you have custody of a child and there's some sort of visitation arrangement from the court that's in place, whether it's with a parent or someone else, know that no one party has the ability to make a change on their own, and that the court still does have the authority to make that change, and that's who's going to have to make a change if one needs to be made. Right now, a lot of people are under the assumption that the courts are closed, but that's actually not the case. While they're not doing in-person hearings right now, they are doing a lot of hearings over Zoom chats, just like this, or through telephonic means. So if you're having an issue right now with a case that's already going on, know that the court can get involved, and it doesn't necessarily have to wait until we're, kind of back to normal. Also, if you're even wondering, how do I even get started with something like this? How do I get started with a custody case right now? You can absolutely make an appointment with an attorney, somebody who is experienced in family law. Everybody is doing things virtually nowadays. You can get online and do a virtual consultation and have your questions answered, and even get started on a case right now, just virtually. A little bit different from normal, but it can still be done. So make sure to find somebody who can help you, guide you through your questions. Next slide, please. I want to take this last part of our topic here on custody to answer a few common questions regarding the custody areas in Florida. And one of the questions that I see a lot is, if I obtain custody of a child through temporary petition or through a concurrent custody petition, can I do that if the Department of Children and Families is involved with the case? And the answer is no. The family courts are able to make decisions regarding children and with who they live with when DCF is involved. And so that decision is going to be sent over to a dependency court judge. They're going to be the ones making decisions ultimately on where that child lives and who that child is being cared for by. And so you may have an option in that way, but as far as a family court petition, when DCF is involved, that's not possible. So one of the next questions that I get is one that comes up a lot, and it basically revolves around parental rights. And so if you have a temporary petition granted, does that terminate the parent's rights to that child? And the answer is no. The parent's rights aren't terminated with a temporary custody petition. Once the court grants that parent no longer has the authority to make certain decisions regarding that child. However, the parent could at any point petition the court to restore their custody rights. So, so the rights are not terminated, not at that point. That is a whole separate proceeding. Now, a lot of people, don't really want to get the courts involved, think this is something that can be just done through family members, and maybe I can just have a family member sign over a power of attorney to give me custody of a child. And that's actually not possible, not in the state of Florida. The state of Florida does not recognize power of attorneys that transfer custody of a child. There are options to provide another family member with the ability to make healthcare decisions for a child. Let's say if a family goes on vacation and the children are left with a babysitter or another family member. Now that person could be able to take the child to the doctor and do things of that nature. But as far as transferring custody over, a power of attorney is just not something that's going to cut it. And our last question that I see a lot, and it's a really important one, is once I have custody of a child, how am I able to protect them if I pass away or I become incapacitated in some other way? And that's a great question, and it's one that I'm going to let Myrna handle because it comes up a lot in estate planning, and that's going to be something that we can tackle in the estate planning section. So take it away, Myrna.
Okay, estate planning. So the idea of estate planning has to do with how to make things as easy as possible during a difficult time for yourself and the people that you love if something were to happen to you. So there's a couple of different scenarios where estate planning is very helpful and recommended. One of them is when you have a healthcare emergency and you are not able to either be there for your child and make those healthcare decisions for your child. You know, say you're traveling, you're on vacation, like Stacy had mentioned, and with parents who want to be able to put someone in charge of those healthcare decisions for their kids if they can't do it. So healthcare directives for yourself and for your children are some of the things that we help people with. Also, if you were to become incapacitated, like if you got really sick and you were in a coma or you developed severe dementia, estate planning can help you and your family through that period of your incapacity. Another reason that estate planning is helpful is to plan for your stuff after you pass away so that you can make sure that the right people inherit the things that you work so hard for. We have different estate planning tools that in our toolbox to help clients and their families. One of them is a will or a trust that acts like a roadmap to let everyone know who you want to be in charge of certain things and who you want to inherit. And with a trust, you are even able to put someone in charge of your property for someone else's benefit, like maybe a minor child or someone that you want to take care of. Designation of healthcare surrogate is a document that you use to appoint a healthcare decision maker to talk to the doctors and to make important healthcare decisions for you if you were in a position where you were so sick that you couldn't communicate that to your doctor. You can also do a designation of healthcare surrogate for minor children to allow a trusted person in your life to be able to step in and make those healthcare decisions for your children in an emergency and in a situation that you weren't available. For example, if you were traveling and out of town. Another document that is very helpful to help families in this estate planning world that I work in is a standalone guardian nomination. And that's a document that we use to allow you to nominate a guardian or even more than one guardian to be able to raise your kids and keep your kids if you were to become incapacitated or if you were to pass away. And that is very important because without a guardianship nomination like this, the court is the one that's going to have to decide who raises your kids. And the people that the court might choose might look really great on paper, but might be someone that doesn't have your values or someone that you might not trust. So with that guardian nomination, you're able to get your preferences known and kind of save them ahead of time with the court. You can also name a guardian for your kids inside a will. And a lot of people do that. And, you know, when I'm working with a family, we always make sure to include a section in the will where we nominate a guardian for the children if a guardian were needed. But it's important for you to know that a will is only limited to what happens after you pass away. And if you were to pass away, your family is going to have to know, you know, where your will is, and they have to turn that into the court so they can start the probate process and activate it. And family members in an emergency, when there's a lot going on, may not know where the will is. It may take a while. So you might have a situation where we don't know who's supposed to be with the kids, and that can leave your family vulnerable to a lot of conflict, and even the involvement of Child Protective Services if the first responders don't know who your kids are supposed to be with. So with that standalone guardian nomination that you see on the slide, that helps to protect your family from that, because that is a document that we file now with the court so that the court already has it. And the idea with that is that if you were declared incapacitated by the court, or if you were to pass away and someone stepped forward to ask the court to be named the guardian, appointed guardian for your kids, your preferences are already saved so that the court has something to go by in making sure that your child is placed with the best person possible. Because at the end of the day, it's all about what's best for the child. So as you can see with estate planning, we have a lot of different tools in our toolbox to help families like yours, and especially families that have young kids. So when we think about guardian and custody, those can be some pretty big concepts. And so we encourage you, if you have any questions about your own guardianship choices for your children, or if you're facing some custody issues with your family or a loved one, to reach out to us so that we can help. Some of the questions that we get a lot of the times are, why do I need a guardian in the first place? Why do I have to worry about naming guardians for my kids? Well, one of the main reasons that it's important to name a guardian for your kids is because the judge who is going to be making those big decisions and signing a court order doesn't know your family. They don't know your values. They don't know what's important to you and who really is the best person to take care of your kids if you were to pass away. So with a guardianship nomination, you're able to make your preferences known and your wishes known so that your kids are raised by the people that you want in the way you want. Another reason that it's important to name a guardian is because a lot of times, a lot of us don't think that we have a lot of money, that, and also that our family is going to know the right thing to do. But when there's a lot of emergencies and people are grieving in that time after you pass away, your family really is helped very much by having your wishes legally documented, so that there's no doubt as to what you really wanted. Another question that we get in my practice is, why can't I just go online and go to a place like Rocket Lawyer or LegalZoom to get my will or to get my guardianship nomination or even a power of attorney? Well, it's true. We live in a modern world where you can go on Google or you can go online and you can get a lot of your questions answered, but there's no way of knowing that the information that you're getting is really accurate. And when you go to those online places to prepare a document, you may not know that that document is really the best tool for you. You might miss out on some planning opportunities or additional ways to protect your family. And you might not know the questions to ask to input into that computer. But when you're working with an attorney, there's a back and forth, there's a relationship, and we can really advise you about your specific situation and make sure that we don't leave anything out that's important to your family. And also, we know how to advise you about your assets and things like life insurance and how they relate to something like a will. If you go online and you try to do a will or a guardianship nomination yourself, you might put the wrong person in charge, or you might sign the document wrong, or you might leave something out, or you might not understand how life insurance interacts with a will. A lot of people don't realize that a will only controls the things that have to go through the probate court to be processed. It doesn't include certain things like retirement accounts or life insurance. So that's the kind of things that you can talk about with an attorney like myself. So Stacy, do you have anything else that you'd like to add before we say goodbye today?
No, just thank you to everybody who watched today, and I'm really glad that you took the opportunity to tune in. And please feel free to share this information with anybody you think might benefit from it.
Thanks for joining us today, and we wish you and your family well. You take care.